can certainly show if Mr. Weinstein is the one that wants to come over, I can certainly show where everything is, but as far as quality, it may have to do with the computer. I don't know, but we serve the same media to everybody.
I would just say if you serve the same media, if there's an enhancement later, you should certainly supplement your discovery and share that with the defense. But is that satisfactory, sir?
Yes, Your Honor.
Okay, all right. Okay, Mr. Steele, next, continuing on, motion to suppress number 3, sir.
Your Honor, you previously denied that motion. I don't know about the written order, though.
We will look at that, and I believe that the written order was filed.
It might have been. I just can't say that.
Can we check on, what is motion to suppress number 3?
Your Honor, the South Court found that I had no standing on behalf of Mr. Williams. It was the District Attorney's Office sending out grand jury subpoenas outside of our state and without the clerk's seal, the District Attorney's seal. That is abuse of our statute and the District Attorney's powers. But the South Court stated that you would not hear the motion because Mr. Williams, there were third-party records. Mr. Williams did not have standing. I objected under due process, but that was the ruling. It did not go much further than that.
And actually, the ruling got spoke as well to the efforts by counsel to pierce the secret proceedings of the grand jury. We did get an order signed on that, and the court did file that order. I can forward it to both the court, Mr. Kearns, and Mr. Steele.
What day was that, madam? What date was the order entered? We just trying to, I just wanted, just for the purpose of the record, make sure we have it, so.
Yes, Your Honor, I'm going to find it.
Okay.
1 second.
All right, no problem.
December 21st of 2022. I hope counsel is telling me. Both on the same day, there were 2. December 21st was the order denying the defendant's motion to dismiss, and the order.
December what date, madam? I'm sorry.
21st, Your Honor.
Okay, that's the next motion. That's the motion to dismiss indictment?
It was the order denying, okay, it starts off, defendant Williams filed a motion to dismiss for prosecutorial misconduct.
Oh, okay.
And that order was entered denying the defendant's motion to dismiss on December 21st, 2022. And it was, I can forward the court that order.
Could you please?
Yes.
Mr. Steele, does that comport to your understanding as well, sir?
Yes, sir.
Is that the next one, the motion to dismiss indictment? Is that the one that is referenced for purported prosecutorial misconduct?
Yes, that was filed on November 3, 2000.
All right, sir.
Has been denied.
Yes, okay.
And there was also an order granting the state's motion to quash that was entered on December 21st, 2022 that related to Deputy District Attorney Mike Sprinkle, and I believe that that specifically is the motion that Mr. Steele referenced in his colloquy to the court just a moment ago.
Okay. Mr. Steele, do you concur, sir?
I do.
Okay, all right. Moving on, motion to suppress number 4 that was filed on November the 9th of 2022.
Your Honor, that was granted previously by the Sovereign Court, and I believe, I did not look at Your Honor Court's order, but the order that Mr. Kearns corrected me stated it was filed already earlier today. That would subsume that motion to suppress the court.
Okay.
That's correct, Judge.
What date was that, sir?
12/21/22.
Thank you, sir. All right. We have a supplemental motion to dismiss filed on November the 10th of 2022.
That's denied previously, Your Honor, and that's going back to the abuse of the grand jury and the powers of the district attorney's office. But that would have been what December 21, 2022, or December 22, 2022 order.
All right. Ms.
I'm not looking at the order, but that it would be the same.
Ms. Love, do you concur, madam?
I do, Judge.
Okay.
Yes.
All right, thank you. Okay, then we have motion to suppress number 5 that was filed on 11/11/2022.
Your Honor, that was denied by the Sovereign Court. I cannot speak of the order, but I believe it's going to be sustained by the December 21, 2022 order for the Sovereign Court, or December 22, 2022 order, because it's the same issue, Your Honor, dealing with the using what I call quote grand jury subpoenas to get evidence outside of the city. So it's similar to what we've been saying.
Okay,
I concur.
thank you, madam. Okay, then the next is motion for discovery number 2 filed on 11/22/2022.
Your Honor, may I have just 1 second?
No.
I have that as satisfied.
Go right ahead, sir. Take your time.
I have that as satisfied, Your Honor. I have those jail calls. So that is been complied with discovery after I filed a motion on November 22, 2022. So that is indeed moved.
Okay, the next one is motion for discovery number 3 filed on 11/22/2022.
Your Honor, that's the same announcement. I was asking for a video of a gentleman, T as in terrific, T as in terrific, and it works now. So I've been satisfied. That does not need any further action.
Okay. The next motion is a motion limiting number 2, motion to strike.
Your Honor, that motion, let me just make sure, that deals with Mr. Williams' challenge under the First Amendment to the United States Constitution, as well as
Is that the rap lyrics motion?
statutory motions dealing with excluding the lyrics. I mean, indictment, you told us on Friday, or when we were last here, I believe it was Friday, that you'd
Yes.
like to schedule that at another time. That is still pending. That deals with lyrics in songs, poetry, artistry, videos, music videos, and the like.
Yeah, I think that I need to finish the expert and I said I'd revisit it after that, so. Okay, I'll put a pin in that for the time being, but we still need to hear it. Okay, then we have a motion in opposition to the state's questionnaire filed on 11/29/2022.
Court already dealt with that, it's moved, and that, obviously, the questionnaire has been given out.
Okay. We have a motion to view and test and inspect physical evidence that was filed on 11/29/2022.
Your Honor, that has been satisfied. We have seen the state representative, we've seen the evidence, and we took advantage of that courtesy, and thank you, and thank the district attorney.
So that was the days that Ms. Love and Ms. Hilton were able to do the outside inspection of physical evidence.
We did it on, I don't remember the dates, but we did it on several days, Your Honor, that's true.
Okay, all right. Is there anything else that needs to be viewed, tested, or inspected at this point in time?
To my knowledge, no. I mean, I know the state has an ongoing obligation.
Sure.
They have not informed us, so I think right now we are good unless the state says different.
Okay.
When I had first crossed the bridge into West Seattle, I could see the city skyline over Puget Sound. I stood on a strip of purple-gray beach sand. A pier house sold hairy mussels and one-hour bike rentals. Copper and metal signs whipped against the wind. Old couples toted bouquets under wooden pergolas. Those singing and strolling on the beach eventually curved around the bend toward the northern arc and out of sight. I wanted to live here by its waters, read its signs, admire the wind as one admires an old friend. The skyscrapers across the water might be a bracelet across my wrist. The Ferris wheel, City Stadium, ships in the harbor. I had never known that joy was a practice.
He's on vacation with us.
All right, sir, we will plan accordingly, okay?
And I'll put that in writing like you suggest, like you ordered.
Yes, sir. Thank you. Okay, the next motion is a motion for a complete witness list and expert reports, analysis, and findings filed on 12/12 of 2022.
Your Honor, the state of Georgia has given Mr. Williams and the parties a very long, I would define it as a witness list, over 300 people, and then they amended the witness list, added other people as well. On that witness list, I cannot find a lot of people. I do not have a lot of dates of birth. I do not have correct addresses. I do not have the telephone numbers. In some cases, I have the name as being B-O-O, and that is the identity of the individual. I would like a firm, accurate witness list because we have been trying to interview every person and finding everyone. We're using tremendous resources and cannot accomplish that. In addition, so that's one part.
How many people are you talking about? Can you give me an exact number of people that you are that fall in that category of no date of birth or address?
Yes, I never counted it up, but yes, I can do that. I just need to recess for just a moment, or when you take a recess, I can count it up. It's very easy to do.
Okay, all right.
But I will give you the exact number. It is a huge amount.
Okay.
And then material witnesses, from what I can tell, or what I believe.
All right. Okay, and then I believe underneath that is a filed on 12/29 of 2022 is a witness list.
That was my witness list.
Okay, all right.
I was just, it probably shouldn't have been on. I just filed.
Well, one is filed on 12/12, and it has motion for complete witness list and expert reports, analysis, and findings. And then the next one is a witness list.
Correct, and that was it's not a motion you need to take up. It was a witness list from Mr. Williams. It's going to be amended. We're still getting discovery, so, but I can amend it soon, and there's over 30 people on Mr. Williams' witness list so far. There'll be closer to 45.
Okay,
And
all
I'll
right.
give the state all the, the accurate information.
I'm sorry, Ms. Love.
Your Honor, I was just going to say that when Mr. Steele does provide to the court the number, if he could just give us people that he has tried to reach and that he has been unable to reach based on the information that we've given, because we too, as we go along, we have people with changing residents, changing phone numbers, sometimes changing birthdays. But I'd like to get those from him so that I can give that to our investigative team, and we can at the very least, based on the ones that he has tried to reach so far that he has been unable to get in touch with, we can find out where those people are now and get him that information first, and then work on the ones that we did not have sufficient information on the list for after we get at least the ones that he's already made an effort to get.
How about,
Found
okay.
that they are bad, like he has bad information, like the numbers have changed or the addresses have changed. But we want to get all of it to him, but I want to get that to them as soon as possible.
How about I do this? How about I let you all work collaboratively as you've all already done already, and just circle back with you on the 24th because you've got other matters on that day, and we can see if that's been satisfied by that time.
Thank you.
Or you're in the process of at least the list has been, you know, the state knows who you're still missing, and I can give you another date to see if that can be complied by, okay?
Yes, sir.
Okay, all right.
There's a I'm sorry.
Oh, go ahead.
There's a subpart to the motion for complete witness list. It deals with the expert reports, analysis, and findings, Your Honor. It's in paragraph 3. And it also deals with the motion for entitled Motion for Disclosure of State's Experts Notes, and that's filed on January 12, 2023, Your Honor. So they kind of merged together. And what Mr. Williams is seeking is that the prosecution, I believe, are qualifying or need to qualify under Daubert. That's why we filed that motion. Potential people that they deem to be experts. And before the Daubert hearing, as well as during discovery, Mr. Williams would like, through me, would like to understand these experts' reports, analysis, data, charts, because then I can trigger whether we need our own experts in this field to explain or impeach the state's witness. And I don't have I have none of that. Your Honor, may I approach for a second?
Yes, sir.
Not an extra copy. Your Honor, I just handed this honorable court and the prosecution. I apologize to everyone else. I did not mean not to bring enough copies. But if you have your computers on and want to file, this is Harris, Harris versus State. It's 314 Georgia, 238 875 Southeast 2D, 659. It's a 2022 case. And on the printout that I've given this honorable court and the Honorable District Attorney's Office, if you look at page 40 of 52, on the right-hand side, and those of you who are looking on your computer, it's Division 6, like 5-6, A as in Elisa. And Your Honor, specifically, our highest court wrote, it's on the right-hand side under A, compelled disclosure of expert notes. The first issue involves the trial court's order compelling appellant to disclose to the state notes written by, and it's the Dr. David Diamond, D-I-A-M-O-N-D, a potential expert whom appellant consulted about incidents involving children forgotten in cars. As part of the reciprocal discovery before trial, OCGA 17-16-2, open close parentheses, little a, as in Elisa, appellant gave the state a PowerPoint presentation that Dr. Diamond planned to use during his testimony. A 2-paragraph summary of the expert's anticipated testimony. The state then spoke with Dr. Diamond. From this information, the state learned that Dr. Diamond had interviewed appellant. The state filed a motion to compel appellant to provide all documentation that Dr. Diamond created related to his interviews with appellant. The trial court granted the state's motion requiring appellant to produce any and all statements and writings memorialized in any manner regarding Dr. David Diamond's conversations, interviews, discussions with appellant. The court scheduled a pretrial disclosure. It was necessary under 24 OCGA 24-7-705 to allow the state an opportunity for a meaningful cross-examination as required by that.
It is our fate to crave what is given to another.
The Iron Throne is the most dangerous seat in the realm. The threat of
with appellant did not call Dr. Diamond to testify at trial. The trial court's pretrial order to compel was proper under Rule 705, which states an expert may testify in terms of opinion or inference and give reasons, therefore, without first testifying to the underlying facts or data unless the court requires otherwise. An expert may, in any event, be required to disclose the underlying facts or data on cross-examination. While the second sentence of this rule is focused on disclosure during cross-examination, the first sentence explains that although an expert may, and it's stressed, testify about an opinion without first providing the facts or data underlying the opinion, the trial court may, stress, require otherwise. Federal courts applying substantially similar Federal Rule of Evidence 705 have explained that the trial court has discretion in requiring disclosure of facts or data underlying an expert's opinion, including the ability to require that that disclosure before trial. Indeed, the advisory committee notes to Federal Rule 705 explain that the rule assumes that the cross-examiner has the advanced knowledge which is essential for effective cross-examination, as safeguarded by the discretionary power of the judge to require preliminary disclosure in any event. And then it cites examples explaining that under Federal Rule 705, the trial court may require disclosure of the basis for the expert's opinion before cross-examination in certain circumstances, including where the cross-examination would be ineffective to reveal the defects in the expert's underlying facts and data in a manner that permits the jury to properly weigh this opinion, cited in United States v. Lawson, LAWSON 653F 2D 299 at 302 7th Circuit, 1981, holding that without criminal defendants' access to the hearsay information relied upon by a state expert, effective cross-examination would be impossible, and explaining that Federal Rule 705 recognizes this requirement. Indeed, to the extent that Georgia's statutes regarding pretrial discovery in criminal cases, example 17, OCGA 17-16-4 and 17-16-7, provide less information about the basis for expert opinions in federal rules. See Federal Rule Criminal Procedure 16. Georgia courts may need to resort more often to pretrial disclosure under the authority of Rule 705. Based on our review of the notes, it was reasonable for the trial court to conclude that Dr. Diamond, based upon his expert opinion, at least in part, on information he obtained from the appellant answering questions such as what he was doing during the drive from Chick-fil-A, if he was in a hurry that morning, and what time he usually went to sleep and woke up compared to the day of Cooper's death. The state was entitled to know any information that appellant gave Dr. Diamond which helped form the expert's opinion. Accordingly, the trial court did not abuse its discretion when it ordered pretrial disclosure of Dr. Diamond's notes under Rule 705 as necessary and meaningful. And in this case, Your Honor, I have nothing. I have a CV from supposed experts. I know you have not qualified them, but I'd like to challenge many of these experts, and I'm talking about cell phone experts specifically, gang experts specifically, and firearms experts if they're going to be received in discovery a new video. That's another motion that's coming up. But I don't want to exclude any other supposed expert. You did qualify, I believe, a expert, Your Honor, for the state in handwriting. But
Handwriting, I think, and also the medical examiner.
And I have no objection to that. But
Okay.
I'd like,
So you're saying gang, firearms, and who else?
cell phone.
Cell phone.
And Your Honor, if it helps at all, I'd like to speak with Mr. Steele or other members of counsels for the defense about the experts we do intend to call, and if we may, I think we may be able to have something worked out or address the issue on Thursday if it's not completely worked out, because I agree that they need a list of I need to know which notes they want. I know that the handwriting expert is not necessary and the medical examiner is not necessary, but I do want to go over the experts that we intend to call and flesh that out further.
Okay.
I think that's something that we may be able to do as well, along with the witness list that is a part of this same motion.
All right, I can follow up on that on the 24th, Mr. Steele. if that's acceptable to you.
Well, I'd like, if you don't mind, I've never been in court, but this is a big case. Can you just grant it, understanding, yes, of course, I am confident others will meet with prosecution, and if they give us everything, that's fine, but especially...
Yeah, I'll grant the motion.
Well, Your Honor,
Thank you.
I'll grant the motion.
as far as the granting of the motion, I don't have any problem with being required to turn that over, but I ask that we get some specificity before if there's a blanket granting of a motion, and if we could be allowed to be heard on the specifics, as opposed to granting a motion without us having to be heard on it. Because we can respond to specifics now. Because we were having the other portion of it on Thursday, I thought that was an optimal opportunity for us to get together and discuss it. And then if the court decides to grant or deny any part of it, we can address it then. But I'd ask that the court reserve granting or denying or ruling on this motion until the state, one, has had an opportunity to respond, even in this setting, and two, until we've had an opportunity to speak more with Mr. Steele. But I would ask the court not just simply grant the motion without allowing us an opportunity to be heard. I interjected only because I felt that we could have an opportunity and we could address all of them on Thursday. But if the court's going to rule, then I'd ask to be heard before that happens.
I think that Harris is pretty clear. You're going to have to turn over the notes. I mean, I'll let you argue it right now if you'd like, but I think that, I mean, this is the most recent pronouncement out of our Supreme Court in regards to expert notes. So I mean, so I think that, I mean, I'll invite your argument if you'd like to make an argument now, but I mean, but I need to kind of button up as much as I can, Ms. Love.
Yes,
I'm not trying to be difficult, but there's a lot of stuff pending. So is there some specific exception, or do you disagree with Harris versus the state?
I do not, Your Honor. And in fact, that's because Harris is pretty plain as to giving the turning over of notes and things like that, and because Mr. Steele indicated he didn't need the notes for the handwriting expert and he didn't need the notes for the medical examiner's office, I wanted to know or hear from Mr. Steele what it is that he continues to need going forward or doesn't want going forward, and without having to endure sanctions for non-compliance, because we left out a part of it. I just wanted to make sure that we buttoned it all down as far as what we were, gearing up to make sure that we have provided or will provide in the future. That's the only reason I wanted to do that before the court made any ruling. I think that we can certainly have the matters ready to come before the court in a concise manner on Thursday, and all of it is a part of the same motion that the court is hearing part of on Thursday. That's the reason that I had asked for that.
Okay. I mean, I'll defer a ruling until Thursday. I mean, but what I'd like there to be is an order. Mr. Steele, I'll leave you to draft that order. You can go ahead and get with Ms. Love about that. And if it's been satisfied, that's fine. But I think, Ms. Love, he's looking for the gang, the firearms, and the cell phone, in particular, the notes that the expert would ordinarily rely upon in conjunction with what Harris tells us that we need to disclose.
Thank you, Your
So it can be a joint order, but I'll follow up on it on Thursday and let you all kind of.
That would be great. I appreciate that, Your Honor. I appreciate that from Mr. Steele. And regarding the gang expert and notes, the reason, just to further inform the court, the reason that I wanted to have an opportunity to speak with Mr. Steele is because when you say notes of a gang expert, I want to know the extent to which, or what Mr. Steele is looking for. There have been interviews, there have been arrests, there have been reports written. So I wanted to flesh that out as well. So I appreciate the opportunity from the court, look forward to the opportunity to confer with